if we're very honest, in case of usability, ease of use for people who have to build an application and infrastructure and stuff like that, all these tools are very great, right?
I wouldn't trust this thing. It's built on Quicksand in the European Union, and it's built on a shaky foundation in the US. So I wouldn't trust this house. I would not try it. I would not sleep in this house.
Hey, Arne, I just heard recently about that people just talked about a transatlantic data privacy framework, and some people, tech people, right, just talked about, this might solve all our problems regarding data transmission into the US, which we right now don't have because there was a guy, John people just called him Schrems and said, he was just someone who just bullied around and frustrated everyone because he was just say, data transmission is not great, but this right now should finally solve all our problems because also the US will also change stuff on their side. But I also heard about some voices again who said, maybe it's not that great as everyone just said. What is your take on this?
Gregor, that's a fantastic topic because it's so hot, it's so new, and it's so interesting, and it's just a thing that will keep us busy for the months and years coming, I'm afraid. So just to start with the broad brush stroke here, both sides are right. It will solve our problems and it won't, at least not in the long run. So in order to understand why that is, it may make sense, if I may, to think for a moment about what the data, the US European Union data privacy framework, what it actually is and what it does and why you need it. And the idea here is to enable data transfers from the European Union to the US. And the data transfer, that's a lot of things. And it's, even if you just have data on your server anywhere and you enable access, even potentially, to somebody from the US, or, that's very interesting, from somebody who may sit in the European Union but has an affiliated company in the US, that is sufficient. Think Microsoft, Meta, or whatever. So they might access your data from Ireland, but their mother company is in the US. That is already a data transfer. That's sufficient. So the point is that if you access a social network, or if you have Google Analytics on your website, all these kind of things, that all is a data transfer. So they're ubiquitous. There are tons of data transfers, basically any website that you open. So it's a big topic. But the problem is that the GDPR, the data protection framework, the data protection law in Europe, is much stricter than any data protection law that you have in the US. So there is the level of protection in Europe is much higher, and in a way, the idea of the GDPR is to say, hey, you can't transfer data unless you transfer it into an environment where the level of data protection is the same or similar, adequate. That's the term. It doesn't have to be exactly the same, but it should be on roughly the same level. It should be on par. That's the idea. Now, how do you do that? For that, you need a transfer mechanism. And the easiest and most ubiquitous, but the easiest mechanism is simply consent. So you can ask your user, and you can ask them, hey, I want to analyze your activity on this website, Google Analytics or whatever. Are you okay with that? And then you click a button, and that's it. But that consent has to be informed. So you have to be very specific and very explicit in giving a user information, which data are transferred to whom, what is being done to them, and so on. So it doesn't work if you have a ton of data transfers. It's just not doable. You need a broader brush, basically, and that brush can either be so-called standard contextual clauses. They have their own problems and issues, or it can be an adequacy decision. That is basically just a decision that the European Union, the Commission of the European Union, comes up with and says, hey, we have found out that the level of data protection in that country is comparable, is adequate, is good enough so that we can transfer our data. So, for example, they will look into these things and will say, in Japan, for example, the level of data protection is good enough, so you can transfer your data to Japan. But then Japan is not the USA, and so far, at least, in the US, it hasn't been good enough. And the reason for that is that the US is basically a surveillance state. So they have very broad-ranging powers under the Patriot Act, under the Cloud Act, which is basically an extension to the Patriot Act, for their intelligence agencies, law enforcement agencies, to look into all kinds of data. And they might not even tell you that they do that. It's very broad, it's a sweeping surveillance that they do. And they don't discriminate. They do it. There are some protections technically for US citizens, but we are European citizens, so we don't enjoy these protections. So basically, you're being snooped upon, period. So, and that means without any, again, framework, and we have a framework now, a data privacy framework, without any such framework, you can't transfer these data without another transfer mechanism. So, the problem is that the European Union and the USA are two very large trading partners, two very large trading blocks. So it would, of course, be nice to be able to do that in a way that is legal, obviously. Yeah. So everybody agrees on that, I guess. The US and the European Union both think that would be a nice idea. And that's why they came up with an attempt trying to squaring the circle. And that is the data, the TAPDF. Do I cite this correctly? The US EU-US data privacy framework. And the idea here is to do this, to do basically three things. And this is how it works. The first thing is that the US tries to take out the sting of its wide sweeping surveillance provisions. So that means that the US, here in this particular case, President Biden has issued an executive order basically saying that we put some safeguards into our framework. Basically, what we do is we limit the access of the US intelligence agencies to what is necessary and proportionate in order to protect our national security interests. So we will still snoop, but only if necessary. That's the idea here to say, yeah. And what we also do is we give you some redress. We give you a way to come up with a complaint to look into basically these data transfers. So you can ask in the first step, I think it's called a Civil Liberties Protection Officer. So basically it's a complaint. You can say, hey, I'm not okay with that. And then this guy will come up with a decision. And if you don't like the decision, you can appeal against that decision to a court. It's called a court, it's Data Protection Review Court. It's being called, from our European perspective, it doesn't really look like a court, it looks more like an authority. But that's what it's being called. And so you do have some safeguards here. I mean, you have some proportionate processing and you have some way of redressing that. So not so terribly bad, right? The problem that we may have here is, we may come to that a bit later, is that they may not be sufficient, and we have had something similar in the past, and it wasn't enough. But that's the American side. On the European side, the Commission has looked into this, into all these measures, into the safeguards, and then has issued a adequacy decision. Basically, I said, okay, we are fine with that. We believe that if all this is being applied, then the level of data protection is adequate, and data may be transferred without any further safeguards to the US. And then the third step is, of course, you can make of it what you want, that if you are a company or an organization that wants to receive data from the European Union, you have to self-certify and to follow certain rules like data minimization and so on that are also part of the GDPR. So basically, you put yourself under certain restraints and you commit to those and say, I'm happy, I'm willing to keep those things. If all these three things come together, you may transfer data now. So, and that sounds fantastic, terrific, doesn't it? Because then again, self-certification, it's something that at least the big tech players, they will do that and they can do that. And actually, honestly, I believe that they can keep their promise. I do believe that when they say we are committed to data minimization, they probably can do that if they really want to. Not sure if they always want to, but if they want to, they could. The problem I see, and not just I see, but many people see it, and especially Mr. Schrems, whom you already cited, sees it, and we may discuss his doings and his works. They are terrific in a way, magnificent. That's the word, yeah. In many ways, or scary in others, depending on where you stand on the divide. He also sees problems here, and here is where the discussion may begin. And this is, we had similar transfer mechanisms already, and they were called the safe harbor. It was an old one, and they were called the privacy shield. And these mechanisms both were struck down by the European Court of Justice. And both times, by the way, the one who brought these cases in front of the European Court of Justice, the plaintiff basically was Mr. Schrems, which is why these respective decisions, Schrems 1 and Schrems 2, are named after him. I mean, it's very rare that you have two European Court of Justice decisions named after you, and both were successful. And then again, a third one is probably in the works, and the target will be the Transatlantic Data Privacy Framework, most probably. So, what were the problems? What were the issues that the European Court of Justice saw? And they were basically in the process as well as in the substance. In the substance, it said, well, you don't really limit the surveillance in the US to what is proportionate and what is necessary. Yeah. Now, this time, in the executive order of President Biden, these words are in there. So the executive order says, well, we will limit, and it's a binding order. So it's a binding order. Yeah? It's not like something they just say. It's a binding order to the U.S. intelligence authorities that says you have to limit your snooping, your surveillance to what is necessary and adequate. But the point is, of course, and this is the thing, this is not what's necessary and adequate under the European point of view, but under the American point of view, what they think is adequate and necessary to protect their national interest. And that may be very different from what the European Union, what the European citizen would expect, or what you would expect under GDPR. So it's, while they use the same words, they don't mean the same thing. That's the thing, that's the substance. And the other thing is, of course, the procedural thing, that if you look into these complaint mechanisms, yeah, you will find that, well, the first one, this it's basically the Civil Liberties Protection Officer, looks a lot like an ombudsman, and that's something we have in the Privacy Shield, and the European Court of Justice says that's not sufficient. And then this Data Protection Review Court is not a court, as you would expect a court to be, But it's basically what happens here is that basically the members of the court are chosen by the U.S. government, yeah. And even your lawyer, the guy who, the advocate who is acting on your behalf and is looking after your interests, is a member of the court. So it's in no way independent. So I don't know what you make of that, but to me it doesn't look much like a court, to be honest. It looks more like, well, a complaint mechanism in-house. Yeah. So there may be some control being some surveillance over the process being taken here, but it doesn't look like it's very really adequate. So and that is, where does it take us if you think about that? First of all, knowing that the European Court of Justice has already struck down two transfer mechanisms that look suspiciously similar to this one, yeah, there is, and Mr. Schrems already having a complaint in the drawer, yeah, and he is not tiring to say that, and I very much believe that he has. And then looking at this, it looks, I'm not saying like lipstick on a pig, because this is a podcast that's intended for general use, but it looks a bit like makeup, yeah, on something that was already existing. It looks very suspiciously similar. So there is a good chance that the European Court of Justice will find this not adequate and will issue a Schrems 3 ruling that will again nullify, null and void this transfer mechanism. That would be bad. But there's one more thing, and that's often overlooked, I have to say. And that is that on the US side, we don't talk about the European Union side, we talk about the US side. On the US side, the whole thing is based on an executive order. That's not a law. That's basically just an order by the president. And it can be repealed at any time. Not just by this president, but by the next president, who could be President Trump. Yeah. And you know how fragmented and partisan US domestic politics is. So this could become a bargaining chip whenever anybody is not satisfied with import, export, trade deals with the European Union, and you know how often these complaints come up. This could become a bargaining chip and could just be revoked at any time with finger snip. Then again, this is solely an executive decision. It's done by the president and his or her advisors. The House would not have to be asked. So this is very easy to repeal. And here's the thing: if you take this together, that this is built on Quicksand on the European side and on the shaky foundation on the American side, I would say that this may last for, 2-3 years, but may it last longer? Anybody's guess. And with that, I would actually throw the ball back to you. I mean, you are a tech guy. What you do is you build tech infrastructure. And my understanding is, and please correct me, you have much more knowledge here than I have, is that such infrastructure is not built with months and maybe 2 years in mind, but has to last for years or maybe even decades in one way or the other. So, and once you are on a certain infrastructure, you cannot just put it out and establish another one, because it's a difficult decision. I mean, with that in mind, how do you see that? What do you make of it from the point of view of a tech person?
So first of all, one thing which sometimes completely confuses me and is a big issue for me is many of those ISPs, like we know, right, AWS or others like this, also stating that they are GDPR compliant, right?
Yeah,
so,
of course they do.
Of course they do. So, and and for sure, first of all, when you have such a big player, you usually tend to believe what they say is correct, right?
Yes, you don't question authority.
So you tend to, and that's also the reason why a lot of people also in the tech world I see obviously using ISPs like AWS, Azure of Microsoft, or also the Google Cloud and stuff like that. And because it's the ease of use, right? So you have a lot of services there, a lot of documentation and how-tos, and all of the stuff is always built around those providers. Mm-hmm. And if we're very honest, in case of usability, ease of use for people who have to build an application and infrastructure and stuff like that, all those tools are very great, right? And also, if they then tell you, yeah, we are GDPR compliant, what you usually do is, yeah, sure, we are using it, right? And that's, but if you then hear something like that, right, that right now it can be theoretically safe, but it can be also theoretically unsafe, because as you just said, right, so the European side says, yep, it's adequate to be going like this, and the US side says, yeah, the current president says, yep, right now it's my order, and you have to follow the rules. But yeah, what happens when the president will change, and another president maybe has another opinion on that? So then that could be different again, and then we are back in the same place. Mm-hmm. At the end of the day, right now, it is the case that a lot of companies and also tech people, I believe, out of lack of, let me say, good guidance also by the European Union, right, to say, yeah, you cannot use it maybe, or you can use it. So right now the European Union officially says you can use it, right? Although the court might say afterwards something different. I believe no one is doing all of us a favor with this. So when you build something on sand, you do nobody a favor with this, because right now we just hope it will last, and then in 3 years we are at the same position, and again we are in a legally maybe gray zone again, and then the fight starts again, and then all of the shit starts again. Sorry for the wording, but we have to say it like this, right?
No, I agree. I completely agree.
And I just always ask myself, right? So either why not build it on concrete rather than on sand right now, right? To say, we right now find a framework which really will work. And as you just said, the following framework is built on sand. It might last, but might not last, right? So to say either we build something on concrete which will work, or for the tech world, we say, hey guys, right now, if we're very honest, we don't find something like this. And right now, we, for example, as a European Union, officially will support any kind of ISP in the European Union to build up something. You cannot be similar like AWS and Co, right? Because you already have a huge amount of time just falling behind. But when you right now say, okay, we see it will not work, and we are brave enough for this, and we will invest in also providers which are GDPR compliant by law, which is possible, right? Or also be more, let me say, also empowering other countries in this regards, which are already GDPR compliant to us, like Japan or Norway or something like this, right? So maybe it is a better impulse for the whole industry to say, it will not work, sorry, right now. We invest right now, so we give everybody money for that, right? We invest into this industry also in the EU and let me say GDPR-friendly countries, instead of always holding us in this gray area between yes and no, which is a nay, we don't know it, which is simply bad, which just leads to that a lot of companies right now are always potentially violating the privacy rights of people, instead of just going black or white and always in the gray zone, which works for nobody. So that's just frustrating.
But aren't they? But that's a very interesting point. That's very interesting point. If I may,
sure.
Because I understand what you're saying. Please correct me if I get you wrong. I understand what you're saying as, okay, companies are basically forced to come up with an infrastructure that going forward may be legally crumbling, may be built on Quicksand in a gray zone, simply because of lack of European alternatives. And at the same time, we don't build these European alternatives that could be, or then again, alternatives in countries that have, I get your message, that do have an actual adequate level of data protection. So basically what I get is, what can we do? What can we do? We are almost forced to go down this path, and we would either have to come up with our own European infrastructure, that would be one way, or we would have to negotiate with the US something that is more lasting, which would probably mean, to be honest, that I'm not saying that probably the US is the stronger negotiation partner, which would probably mean changing the GDPR, to be honest, to be fully honest. And of course, both things have drawbacks. I mean, even if you say we do come up with a European digital infrastructure that is adequate technologically, and we go away from using American infrastructure, it would of course mean a balkanization, a compartmentalization of the internet. I mean, something that is being discussed and talked about, that there may be a point in time where we'll have an American, European, and a Chinese internet, and they will no longer be able to communicate effectively together, which is of course against all the ideas that originally the internet was built upon. But that's what I understand. Is that understanding correct? Is that what you're saying? That these are the alternatives you see from a technical perspective?
I definitely see. And the point is, right now we already have some alternatives, right? So, but obviously these are not international companies, because their market is most likely markets in Europe and also Germany, for example, right? So they are regionally. but all of them are also very powerful and great. So obviously they don't have the huge amount of features like, for example, AWS has, right? Because again, they are manpower and years ahead of us, right? But so for example, I also worked in a lot of startups so far, right? So which are starting from a certain point. So far, if I'm very, very honest, the majority of those companies don't needed all those features which AWS provided, right? Also German companies, and then some of them, so several people of us know, like for example in Hetzner or OVH, for example, right? So all those companies already have a lot of a great feature set, which for the majority of the companies also in the EU are completely sufficient. But the first thing which comes into their heads is, AWS and it's GDPR compliant. And right now, again, because the EU says, it's great because we are negotiated with the US again.
But doesn't it mean, just to entertain the thought, and again, doesn't it in a way mean that in a way we as Europeans, from a point of industrial policy, we are sabotaging ourselves?
Yes.
I think so.
I strongly believe this. And again, there are so many features which all those European providers don't have. But here right now comes another catch here, which I by myself also already stumbled into. When we are in this environment of these big players, right, which have so many great features, which you don't have to build by yourself.
Yeah.
Then you build on them. So like, for example, a special database type or AI type or whatever. But the problem is then you always jailed into their ecosystems because you cannot migrate away from them. Except you're
locked in. There's a lock-in effect, basically. Yeah?
So there's the term vendor lock-in, right? So you're locked into this vendor and you cannot get out of them. So which makes it funny again somehow. So in a tragic way, right? So, but for example, when you are, let me say, don't step into these traps, and for example, based on industry standards which are not bound to one vendor, and there are a lot of them, like databases, right? You not have to use, let me say, vendor-specific databases because there are a lot of, let me say, open source, but also paid versions of powerful different databases which you can use, right? Okay, you have them operated by themselves, or you can, for example, look for an ISP who can operate it for them. But again, the technology which you're using is a standard, right? But again, the majority of the people forget this. And again, I also stepped already into this trap, right? Say, that's easy. I just right now click here and then it's there, and they're advertising their own stuff higher than, let me say, the industry. So let me say the standards which you can use cross them. But so I believe the EU, by not promoting this kind of, let me say, standard-based services, which are also operatable in the EU, manipulates us in the wrong way or sabotages ourselves, but also we software developer by ourselves also sabotaging ourselves by trapping into the advertisement hell again by saying, there's a very great service which this ISP develops, which is greater than industry standards. And the truth is, often that's correct, but the benefit you get out of this somehow betterness than the industry standards for the price you pay for that is maybe not often the greatest thing. So that's somehow, again, frustrating how we trick ourselves all the time again, right? And also the European Union again, like this.
Yeah, this is very interesting because I have, to be honest, I'm a lawyer and I have my own view on things. And of course, I come from the legal perspective. And I haven't seen it as clearly, to be honest, as you put it here, that basically we have this vicious circle of vendor lock-in, and now we're there, and it's even easier, and then we have a critical mass and so on, and then everybody knows these things, and then we have the European Union not only not trying to break this, but actually actively promoting it, so being a driver in this development. That's very interesting. I haven't seen it like that, to be honest, but it's interesting and entertaining, if I may say that, value neutral. thought. Very interesting. But let's, if we can agree on this analysis, what do we do about it? I mean, you already mentioned open standards, open source, and then again, I could throw in maybe a bit of legal nudge, legal push. Is there anything else that you or I can think of promoting a bit more? I don't know. Data sovereignty used to be a keyword, that I still remember, that we just seem to have forgotten with this transatlantic data privacy framework. What can we do to further that? To anything you can think of?
Yeah, that's a very great question. I believe right now, as the authorities are, I believe, don't do right now the smartest stuff they can do. Let me put it like that. Yeah. So,
yes.
Most likely. So, like I also just decided for myself several years ago. Before I decide for a provider and say there's only one solution for that, right? I first start with this: what I do, what I really need. So, what are my real requirements to solve a problem?
Yes.
So. But I believe that's not just for software developers, that's for everyone, right? So for everyone, at first start with what are your real needs / your problems you have to solve.
Yeah.
And then very straightforward, what are all, let me say, meaningful providers on the market you have who can provide this feature to you? So in just, let me say, in your favorite search engine way, right? So just typing in there, for example, I need this service, and then also type EU. Sometimes it helps, for example, me to find at least alternatives. So not always, it's not always convincing, right? But it just takes me some minutes more to make the small research for the service. And I would say in the majority of the times, you might find a good alternative, except you have a very special, let me say, product you're offering with very special requirements. But I would say, if we're very honest, the majority of the apps which come into the markets nowadays are something like apps which need some, let me say, servers in the internet to operate, and nothing of this is very special. Also, not AI stuff is not special nowadays anymore, right? So, and just take a moment back and say, okay, do I have to take right now the most obvious thing, or I just give it a search in the internet, right, to just look for some alternatives before I make my log into this ISP. So, and when I have then two, let me say, offers there, and both offers are most likely the same. The one is just more famous, and the other one is in EU. And I know I'm right now in this gray zone. And as you just described right now, right, and this was also for the other, let me say, rulings before, right, for the Schrems 1 and 2. And afterwards, you always know, okay, how they should fix it like that, right? Then I would say, in doubt, when both have more or less the same feature set, both are more or less equally prices, so something like in the area of 10%, I would say, okay, just I don't care so much, right? I would gain favor of the EU stuff because there I'm automatic, so I'm easier GDPR compliant rather than when I go with the gray zone right now.
Yeah, maybe you can't do it at all. I mean, it's perfectly possible depending on how this will play out. And of course, it's hard to.
It's gambling.
It's hard to judge. And it depends, of course, a bit on what you do, and then again, which other transfer mechanisms you may be able to use or may not be able to use. So we can't, of course, answer this question without looking into any individual case. But as a lawyer, I would say you're much safer, and I would, if I was a data protection officer of the respective company, or if I would counsel them as a lawyer, then I would sleep much more sound if they would use infrastructure that is located but also governed. Again, we must not forget this governed. In the European Union, because then again, the bomb here may go up at any time. And it may be actually quicker than many people think. And when I hear, but now the European Union can do this, they have decided this, they have looked into this, so they did the last 2 times. So, I mean, it's right now it's 2-0 for Mr. Schrems. So it's an immaculate track record. So,
But just
Whom
one
are we
point.
betting on? Yes.
But just one point I want also to just pick up right now. You asked right now a moment before regarding the separation or the split up of the continents, right, in regards of the internet.
Yeah.
So the point is, if the laws are the different, like now, and they're hard to, let me say, bring together.
Yeah, and very hard to reconcile.
So,
I mean, it's very difficult, actually. It's a difficult task.
Then I believe strongly, yes, there's a risk. But the risk is not in creating other services and other continents, right? It is more the risks that are incompatible laws there existing, right? To force us to look for the solutions.
Yeah.
But at the end, we also have to be honest, right? It's more like this, having a European company and want to operate their data, right? And they're in the infrastructure in a green way, right? So in green, in case of you are in a zone where you don't have problems in this regards. But it still leave us that we might, for example, use services like Netflix still, right? And also like Spotify and all those services. Okay, no, Spotify is right now from you. A better example,
Sweden or something.
Yeah, sorry.
Yeah, I think so. Yeah.
But you know what I mean. So or Amazon Prime, right? So
yeah.
Who should stop you to do that? But at least when you're a European company, you can develop a product without, let me say, the bad feeling to break the law of the citizens of the EU you will also be in, right? So I would say there is a small risk to break up the internet apart, but it's not the biggest one, right? So it's more likely giving people choices to be legally compliant rather than forcing to be uncompliant.
Yeah, but this goes back to and I don't have much more to say, just to wrap it up here maybe, because that leads back to what you said, that it might be just nice to have an alternative. And right now we don't have that, and we don't currently, this is me the lawyer speaking, we don't seem to set any incentive to create such alternatives by basically saying, and I translate here, hey, it's okay even though it's not okay. So, but do it anyway.
Yeah.
And this is actually what bothers me from the legal side. But then we shall see how this play out. I mean, do we have any last words, Gregor? Anything to to wrap this up?
Yeah, for me, for everyone who is seeing this, my only recommendation is at first look for alternatives before you just always go for the obvious path. Yeah.
I have nothing to add. I have made my point clear, I think, throughout the thing. I wouldn't trust this thing. Again, I just can come back to my picture. It's built on Quicksand in the European Union, and it's built on a shaky foundation in the US. So I wouldn't trust this house. I would not try it. I would not sleep in this house because it may crumble at any time without any warning. That's just my take.
Yeah, great. Then
so
it was a pleasure.
Let's go home and let's meet next time in our podcast, which doesn't have a name yet, I think, does it?
Yeah, we have to find one.
We have to find a name. So whoever is listening to that, if you have a proper name for this, by the way, like and subscribe. It's very important. Doesn't cost you anything. Helps us a lot. If you're interested in these topics, if you found this entertaining or enlightening, or even if you didn't, still subscribe and like, because it still helps us. If you have a good name, please let us know in the comments. Thank you so much.
See you next time.
See you next time.
Bye.